Hi, I'm attorney Shawn Jaffer and with Jaffer and Associates, and I want to talk to you about credit card lawsuits in Texas and how my firm handles them. And or if you don't want to work with a lawyer, maybe this information will actually help you in defending your own lawsuit. Okay. So the first things first. What happens in Texas, particularly, is when you're served with a lawsuit, you're going to have a piece of paper called the citation. Citation is going to tell you how long you have to respond to the lawsuit by filing an answer or a responsive pleading, could be an answer or it could be a motion to dismiss. Okay? So the first thing you do is look at the piece of paper called the citation. It'll tell you that you either have, usually in Justice of the Peace Courts, 14 days to answer, or it'll have something like 20 or 21 days to answer if you're in county or district courts in Texas. Now, if you're watching this from another state, the process is pretty similar. Just look on this, it'll either be called a citation or a summons or something like that, and it usually tells you how long you have to answer the lawsuit. So number two, what you're looking for is the document is going to be labeled in Texas as an original petition. That itself is the lawsuit itself, okay? Or if you're watching in other states, it might be called a complaint, okay? Now, in the complaint or original petition, the first part of it, at the very top of it, it'll have something called a caption. That'll tell you who the plaintiff is. That's the party that's the party suing, okay, bringing the lawsuit. And then it'll say defendant, and that should have probably your name or whoever is being sued. Now, the other information on the other side of that caption will tell you which court it's in, the case number, and county and other information. Now, what you want to do is you want to skim through the lawsuit and read it and go down to the section called facts or factual allegations, okay? In that section, it'll tell you how much you're being sued for. Now, the dollar amount is important. My firm, we base our legal fees on the amount of the lawsuit. And the reason we do that is the higher the lawsuit, usually the more their fight and more effort it takes for us to settle the case or take it to trial in certain situations. If there's not enough documents or evidence for them to get a judgment, we'll recommend that. Okay, but each case is different. Okay, so going forward on this one, you want to read that section, and then the last section is called prayer for relief. Okay, in the prayer section, they'll ask the judge to grant certain things. They're going to ask for the dollar amount of the debt that's owed. Usually, the second they're going to ask for is going to be if they're asking for attorney's fees, it'll be listed there. If they're asking for interest, it's going to be listed there. If they're asking for court cost and other things, it will be listed in that section as well. So that's where you want to see how much you're being sued for and what else is going on. Okay. Now, the typical process is you want to respond to the lawsuit, okay, by the deadline. So the first thing you want to do is if appropriate, you file either an answer or you file a motion to dismiss. I'm not going to get into the motion to dismiss. It's a little more technical for this video, but we're going to talk about an answer. In Texas, when you file an answer, you want to file what's called a general denial of all allegations. So you're going to file a general denial answer, okay? If you admit to everything in the answer, then there's no reason for a trial because you've already admitted. So that's very important that you consult with an attorney to understand your rights as to why you should admit or should not admit or deny the allegations. Because if you deny the allegations, then there will be a trial. If you admit the allegations, then you're in essence admitting everything and there's not going to be a trial. Okay? So it's very important to file a general denial of all allegations or the allegations that apply to your situation, which an attorney should be able to guide you through. Now, once that gets filed, you want to make sure it's filed with the court and is file stamped, okay? And a copy of that is served on the plaintiff. Now, you can do that electronically if you have e-file, or you can do that by mail. But when you file something with the courthouse, you're required to send a copy of whatever it is you filed to the other attorney, to the other party, okay? And they're usually represented by an attorney. So you have to send a copy of it via email or by mail or electronic service through like an e-file system that the courts use, okay? Now, once that's done, what happens is they filed a lawsuit, you responded to the lawsuit, now the ball's back in their court. So in justice courts in Texas, they're not allowed to start the discovery process unless they file a motion to open discovery. Now, so a couple of things happen at this point. Usually, so if you're working on your own, you can reach out to the opposing attorney and work out a settlement. You can litigate the case. You can file a motion to open discovery. Discovery is a process where you can request documents and have questions answered under penalty of perjury from the other side, and things like that. So it gets a little bit complicated here. But what you're looking for in a typical credit card lawsuit defense case is, were there any documents attached to the lawsuit? If there were documents attached to the lawsuit, then you want to evaluate the documents to see what's going on. Now, it makes a big difference between whether it's the original creditor that's suing you, such as Bank of America, Capital One, American Express, Wells Fargo, like a somebody who you borrowed money from, because they will, in almost every circumstance, they will have all the records they need to prove their case. The cases where we are successful at getting dismissals or getting deep discounts are cases where the other side is a third-party debt buyer. So the debt buyer buys a debt, and then in those cases they had to prove what's called a chain of title. They had to show that I purchased this account from this company, who then purchased from this company, who then purchased from this company, who then may have bought it from the original creditor. So if there's ever a break in the chain of title, then their case falls apart. Now, that only applies with third-party debt collection companies, okay? And those are the cases where we have a much higher success rate at getting dismissals or deep discount, because they know that we know that their chain of title may not be complete. And if their chain of title is not complete, then there's a possibility that at trial the judge is not going to award them the damages that they're seeking, because they cannot prove that they are entitled to collect the collect the debt, okay? So we evaluate cases for different things. A lot of times when you get a copy of the original credit card agreement on these credit card debt cases, you want to check for a couple of things. If you're handling this yourself, you may want to see if there's an arbitration clause in there, because we check for those ourselves. If there's an arbitration clause, then we may advise our client that, hey, you know what, maybe you should file a motion to compel arbitration. What that does is it forces a case to be moved from court to arbitration. Why should we do that? Because the other party has to pay for all the arbitration fees, which may be more than the amount of the debt that they're suing for in many instances. So that causes a dismissal, okay? Or, for example, if you have other situations where the documentation is incomplete, well, then you can move for a motion for summary judgment after you open discovery. So first step is you have to open up the discovery process, and you have to request all documentation related to the account and debt that they have, and relating to the consumer, which would be you, for example, and then see if there's any holes in the documents. If there are holes in the documents, then you move for a motion for summary judgment, which says, Judge, there's no way that they're able to establish that they have a complete chain of title, or there's missing documents, and therefore this case should be dismissed. So there's different strategies that are employed when you're dealing with a debt collection company. And my firm, where our attorneys here, we go through each case. We look at the credit card agreements. We look at the amount of the debt. We look at if there's any arbitration clauses. We look at if their documentation is complete, if the chain of title is complete. If those things are complete, then we go ahead and we file the appropriate motions. Now, the appropriate motions here could be a motion to dismiss at the beginning. It could be a motion for summary judgment after we've done discovery. It could be a motion to open discovery in justice court. And then it could be our discovery package that we send out to requesting production of certain documents that we need. It could be questions that we ask them under penalty of perjury. There's a lot of different things that happen in these cases, but if you're interested, and if you need a Texas defense attorney for credit card cases, call Jaffer & Associates.